各位在座的各位产业先进，大家好，大家午安。非常谢谢大家宝贵的时间能够跟我们在一起，我们有这个研讨会的活动。那还有就是我们今天很费心的，我们今天中场休息，外面有一个茶会，就在门口出去的地方。那结束5点半之后，我们有一个酒会。那很希望各位能够留下来跟我们互动，因为除了我们有一些事情想跟各位分享，我们有一些更希望的是一个双向的互动，我们也想知道各位比如说对我们今天的题目，或者对各位产业上的问题有什么看法。在台湾我真的觉得很奇怪，就是研讨会的时候大家都很专心，然后研讨会一结束，这样轰就回家了。那我在美国通常是酒会的人数会比研讨会的人数多了，所以试试看看大家能不能够习惯，我们很希望能够有这个机会跟大家有一个双向的互动。那差不多是这样。那我首先我要跟各位说明，我们特别感谢在我荧幕上的这些单位，因为他们协助我们宣传，我们有机会能够邀请到大家来，所以我们非常非常感谢这些跟我们一起合作这个研讨会的各个单位，非常感谢。那接下来我很快的介绍一下我们今天在场为各位提供服务的理律团队。来，请我很快的介绍一下。那为什么会特别安排一个理律的团队跟各位介绍？是因为等一下在中场休息或酒会的时间如果各位有任何的问题，方便的话，你们可以随时私底下问他们。那好处是什么？今天问跟明天问的差别是什么？是你今天问你不会收到账单嘛？你明天问，按照我们的 policy 应该是要让你收到账单才对。那回答的问题都一样，但是费用是不一样的，所以欢迎这个大家多加利用。我首先介绍我们的孙宝成，这位宝成是个好人，但是有时候我们喜欢欺负他，因为你光看前面就知道他的 title 一行快要写不完。那我们都很嫉妒，但也表示说大概形形色色各方面的问题，大家都可以跟宝成来讨论。那他在我们事务所，他做很多机械专利、设计专利申请跟侵权。那接下来我跟各位介绍，在我最右手边的是庄玉信庄律师，请挥挥手。庄律师他专利诉讼做很多一般的法务，还有他对药事方面特别熟悉。那我的背后我的所有的重大的诉讼案，只要是成功的，其中一半的重大的帮助的贡献都来自于庄律师。那另外一半在哪里？等一下跟各位讲。那个金若云金专利师，他是电子的，尤其是通讯的，所以现在就是他的 workload 是蛮大。那他除了是我们台湾的专利师之外呢，也是那个92公司另外一边的代理人。那许文婷专利师，文婷也是一样，他是两岸都有的，所以他们总是可以做一些我做不到的事情，我也不知道为什么。那文婷他是化工背景，也做化工的诉讼，也做蛮多申请的。那今天理律的团队都有带一个名牌，所以欢迎各位在有空的时间能够跟他们多聊聊。非常谢谢大家，谢谢今天的理律团队，谢谢。最后一位重要的理律团队我要跟各位介绍，但是他不肯上台有点害羞，所以请各位稍微回个头就是在最后面的我们的很资深的合伙人蒋大中蒋律师。今天有很多我想跟蒋律师的客人是客户，那他其实在这个活动的筹办，他是帮我们最多的忙，但是他说他不要上来问，那我们就请大家回个头。那其实我居然忘了介绍我自己，但你们应该都认识我了。我是发信给你们的人，我是张哲龙。我是理律的合伙人，那我大部分都是做专利的诉讼。好，非常谢谢大家。那我们现在开始介绍我们今天的 speaker 和我们合作的理由所So please allow me to introduce our 3 guest speakers today, and a very good firm in Germany, Kuhn & Walker. So this year is Kuhn & Walker's 40 years anniversary. So they spend all the efforts coming to here and they pay their own cost. And one thing I really need to tell you, that is all the costs incurred today, including the rent, including the food, including the drinks, they are 100% sponsored by Kuhn & Walker. Thank you very much. So our first speaker is Dr. Michael Topf, please. Dr. Topf is specialized in the all kinds of patent prosecution and some litigation. And after you read the presentation material, you will find that's really informative about today's topic. So later on, Dr. Topf will give us a first presentation. And because of his very tight schedule, so he would need to leave after the first presentation and the tea break. So he will directly go to the airport. So if you have any questions, please come to him directly during the tea break. After the tea break, he's on the way back to the Germany. And our second speaker, Mr. Asen, Mr. Dalif Asen. Maybe you do not know, but Mr. Asen, he came last year and he gave a very good speech at the patent office, our intellectual property office. He gave a speech to all the patent examiners about the latest European patent practice. It was very good, so if you Google his name, you can find a photo on IPO's website together with the Director General Wang, now the Deputy Minister of the MOEA. So you will know how good he is later. Thank you very much. And our last speaker today, allow me to shift back to Chinese channel. 我们的陈家金陈律师，他是我们理律的初级合伙人。那我刚才说我所有成功的案子背后的另外一半就是来自于他。他跟我们庄律师都是一样，都是我们的初级合伙人，非常有经验。那陈律师除了做专利的相关案件之外，因为他早期的律师工作涉及到一些 non-IP 的服务，所以可以说是全才。所以他是我们今天其中一位 speaker。再次谢谢大家，然后废话不多说，我们现在要把这个时间交给我们的第一个 speaker。Let's welcome Dr. Topf。
你好。So thank you for your nice introduction. Now, the topic of my lecture today is strategies for patent prosecution in Europe, especially in the aftermath of the public vote in the UK to leave the European Union, the so-called Brexit. I'm going to first discuss the existing possibilities how to obtain patent protection in Europe for you, and we will see that due to this national character of the existing possibilities to obtain patent protection, we have some disadvantages, and the unitary patent or unitary patent system, including the unitary patent and the unified patent court, is thought to overcome these objections. However, due to the Brexit, or this public vote of the UK to leave the European Union, there is major uncertainty now how this unitary patent system is going on, and I will discuss not only the unitary patent, what it is and how it can overcome the disadvantages of the existing European patent system, but also some possible scenarios, what kind of effect the Brexit might have onto the unitary patent system. So let's first talk about the existing situation, the patent practice as we have it now in Europe. We have basically two different kinds of patents. There are national patents, which are granted by the national patent offices, and we have in Europe the European Patent Office, which grants the European patents. So European patents, this term might be somehow misleading. It is no unitary patent right in the sense that you have one single patent right for which you pay maintenance fees to one single institution and which you can force in one single court procedure before one court with the same effect over whole Europe, but it is just a centralized examination procedure. That means after grant of the European patent, Then there is a validation. You have to validate this European patent in the countries where you want to have the patent protection in these countries. And only where you validate your European patent, there you have a patent right. And actually this patent right is then a national patent right, which has to be maintained on a national basis and which has to be enforced on a national basis. So you have to pay the maintenance fees to all the individual, in all the individual member states, and also have to enforce this European patent separately in court proceedings in each European member state where you want to enforce it. So the European patents are no unitary patent rights in Europe yet. Now this is a graphical overview about the different possibilities how to obtain a patent protection in Europe at the moment. Starting from a priority filing, you can file a European patent application claiming the priority of your first filing, maybe in Taiwan. And then you have a validation and end up in national rights as shown here and as explained before. So for all these national rights, you pay maintenance fees separately for each individual country. So this involves high costs, and also it involves administrative burden for you because you have to manage all these different national rights. Then the second possibility is to directly file national patent applications with the national patent offices. Then you have the examination of the patent application before the individual national patent offices separately, and end up again with national rights, which are in this case national patents, for which you of course also pay the maintenance fees separately for all these countries in which you have applied for a patent and which you also have to enforce on a national basis. And just to be complete, you have the centralized application possibility by filing a PCT application. This PCT application provides for a centralized application. You file only one single application with effect to nearly the whole world. Nearly all countries and regions are available via the PCT, except Taiwan. And from this PCT application you can then enter the regional phase in Europe or enter the national phase before the national patent offices to start the examination, in this case at the European Patent Office or here at the national patent offices. So the advantage of filing a PCT application is to win time for deciding where you actually want to start the examination. So you can shift the decision making for where to actually spend the money for the examination procedure, which of course involves costs. The decision whether to file a European patent application or whether to go to the national patent offices and file national patent application depends on in how many countries you actually want to have patent protection. If you want to have patent protection in many European countries, then it's worthwhile to file a European patent application. This is then more cost efficient. However, if you seek for patent protection only in a few European countries, then it's recommendable to file national patent applications with the only few national patent offices. Now, what are the deficiencies of this EPC system, of this European patent system, which already provides a centralized examination procedure, as I said, but results actually in a bundle of national patent rights after the validation phase. So we have this bundle of national patent rights after the validation, and as I already said, you have to pay the maintenance fees separately to all these different national patent offices. This involves high cost and also a high administrative burden. It's very complex to manage and maintain the European patent after validation. So what we want to have is a unitary patent right for Europe, where we have to pay the maintenance fees only to one institution, and such unitary patent would be the planned so-called unitary patent, which actually is a European patent granted by the European Patent Office with unitary effect for at present 25 European Union member states which participate in this system. So you pay the maintenance fees only to one institution, with actually less costs if you seek for patent protection in many European countries. And also regarding enforcement, Detlef will talk about that later. For the present existing classical European patent, you have to enforce this European patent separately in each country, resulting in high costs. And also, legal certainty is a question, because all these different courts, they have a different tradition, and you may have, with the same infringing product and the same claims, have different outcomes. Maybe one patent court decides for infringement, but the other does not. So the solution to that, with this unitary patent system, which is planned, we have the unified patent court, which is one single court, which would then decide all the cases for the unitary patents, and actually would then also later decide necessarily all the cases for the classical European patents as well. The solution of the unitary patent system is implemented by basically two regulations, which are European Union law, and one international agreement, which is the UPC agreement. So one regulation creates law for the European patent with unitary effect, the unitary patent. One regulation is responsible to provide rules for the language regime, and the agreement is about the unified patent court. Now, what is the unitary patent? I said already that it is actually a European patent with unitary effect. So up to grant, it's just a normal European patent which is examined the same way like a classical European patent, but only as a post-grant option you have the possibility to file a request for unitary effect. And then, after registration, you have, instead of a validated European patent, a European patent with unitary effect, for which you pay the maintenance fees only to the European Patent Office, so only one institution to which you pay the maintenance fees, and which you can enforce then before the unified patent court within one single court procedure with effect to all the participating European Union member states. So very important to point out again, up to grant, there is no difference at all. So we rely on the known examination procedure of the European Patent Office. And after grant, you then decide, you can still, if this system enters into force, it's not entered into force yet, I have to point that out again. If it is in force, this new unitary patent system, then you have the choice for the participating European Union member states to either file a request for unitary effect or alternatively still use the classical validation system and validate your European patent in any number of European countries which you like. So that is a graphical representation. You have the decision to grant a European patent. Then there comes the publication of the mention of the grant, which usually is the publication date of your European patent. And then you have 1 month time period for filing such request for unitary effect. And as we will see, we need during a transitional period to file one translation also within this 1 month. So that's quite a short time period. So you should make your decision whether to use this unitary patent possibility or not well before the publication of the patent, because 1 month is rather short time for translating. And afterwards, payment of renewal fees only to the EPO. Whereas, for the validated European patent, you pay the renewal fees to the National Patent Office. So all the European states which are available for the unitary patent, you can get the unitary patent. And for all the other European Convention contracting states which are not available for the unitary patent, you have to validate or can validate to get these national rights. So not all of the European Convention contracting states will be available by the unitary patent. Now, who is in, who is out, and who might join? The regulations for the unitary patent. These regulations are European Union law, as I said, and that means only European Union member states can participate in this unitary patent system. So, at present, these regulations will be effective for all European Union member states, except Spain, which rejected to participate, Poland, which did not sign the Unified Patent Court agreement, and except Croatia, which joined later after this agreement was signed by the other countries. And what about UK? I will come to that later. So it will not be available for all the remaining 12 European Convention contracting states, for which you can get a classical European patent, but which are not member of the European Union. The agreement on the Unified Patent Court is available for European Union member states only, 25 of which have signed so far. So we have 28 European Union member states at the moment. Spain, Poland, and Croatia have not signed this agreement, but may sign at any time later. Here you see a colored picture or map where you can see which countries are member to which agreement or which are member to what kind of union. So the orange and the green one, Italy. It's green, has a different color than the orange countries, orange-colored countries, despite being the member to the same agreements and the European Union, because it joined this unitary patent package later. So originally, Italy, which is here in green, did not participate in the unitary patent, nor in the Unified Patent Court agreement. So, but now orange and green colored countries, they are European Union member states, they are contracting states of the European Patent Convention, and they participate in this unitary patent system. The pink colored country, which is Poland, is a little bit special because they participate in the unitary patent system. There is a so-called enhanced cooperation within the European Union, which provides the possibility that some, but not all of the European member states are bound by these regulations, which are European Union law. So these regulations are applicable not to all European Union member states, but only to the European Union member states who actually participate in this so-called enhanced cooperation. I don't want to go into detail for that right now. So Poland participated in this enhanced cooperation, so they have a regulation for the unitary patent. However, they have not signed yet the agreement for the Unified Patent Court, and that actually has the consequence that for Poland, the unitary patent will not be available right now. The gray country, which is actually Spain, they totally rejected until now the unitary patent system. They don't want to have that due to whatever reason, and at the moment they are out, despite being a European Union member state. And the blue-colored countries, quite still many, they are contracting states of the European Patent Convention, but do not participate in the unitary patent system because they are no European Union member states. So Europe is not Europe. There are different Europes, geographical-wise, or regarding the European Patent Convention, or political-wise, then it's the European Union. So there are different Europes. Now, when will it come? As I said, the unitary patent system, there are regulations which are actually in effect, but not applicable yet. And the Unified Patent Agreement is signed. However, it did not enter into force yet because there has to be some ratification process. So this whole system did not yet start. What has happened for this system to start? So the Unified Patent Court Agreement will enter into force on the first day of the 4th month after deposit of the 13th instrument of ratification or accession in accordance with Article 84 UPCA. So it means 13 countries have to ratify. What does ratify mean? The agreement is already signed, but by a representative providing its signature, but still this signature has to be, and the agreement has to be ratified in the individual countries. Usually this is done by the parliament, who has to agree to this agreement. So the countries have different requirements for the ratification, but you have just to know that there is necessary another formal procedure to ratify the agreement. Now, 13 countries have to ratify before this agreement enters into force. And here you can see the countries for which we have a ratification right now. Austria, France, Sweden, and so on. So we have not yet 13 states where we have the ratification. And also, we need a ratification at least in the 3 most important states, which are at the moment Germany, France, and the UK. UK, as a European Union member state, they have to ratify this agreement. And if they do not, then the system can at the moment, as long as the UK is a member of the European Union, not enter into force. So there's a strong political will and much effort done to get this system starting, but there remains a residual risk that the ratification process fails, and especially, as we will see, after this public referendum of the UK, there is at least the danger of a serious delay of years. Now here, I want to explain different scenarios to explain the different possibilities how the Brexit might influence the start of this new unitary patent system. On the left side, you see a timeline for the process how the UK actually would legally exit the European Union. Up to now, we just had the public referendum in the UK where the public said we want to leave the European Union. However, for the UK to actually leave the European Union, it is necessary that the government service a notification to the European Council of its intent to withdraw from the European Union, and then a 2-year period for agreeing on future relationship between the UK and the remaining European Union member states would start. This 2-year period can be prolonged if there's mutual agreement about such prolongation. And only after such 2-year period, or if we have an agreement between the UK and the remaining European Union member states, then actually there would be the legal exit with all the consequences. So at the moment, the UK is still a member of the European Union. Nothing has changed actually yet. Actually, the government is even not legally bound to start the actual process to leave the European Union. However, they have said that they intend to do so because they feel bound, even if not legally bound, by this public vote. So now, what are the scenarios for the unitary patent system? One possibility is, in the middle line, the UK ratifies the Unified Patent Court Agreement, then the unitary patent system would enter into force with the UK. Then there comes the legal exit of the UK, and then there are two possibilities. Either the unitary patent system then continues without the UK, because the UK, when it's no European Union member state, then European Union law would not be applicable, of course. They cannot participate then in this system by the European Union law. But there are possibilities to make some additional agreements, so-called protocol, that the UK can still participate in the system by some extension of the effect of the unitary patent, similar like the extension states which we have for the classical European patent system. So the system could then, after the legal exit of the UK from the European Union, still continue with or without the UK. Or the UK does not ratify before they leave the European Union, then as long as the UK is a member of the European Union, the system cannot enter into force without such ratification of the UK. And then that means we have to wait, at least for the legal exit of the UK from the European Union, before this unitary patent system can enter into force. And then, as you can see from the timeline on the left side, this may take several years. Now, the unitary patent protection may be requested for any European patent granted on or after the date of the application of the regulations, which means after this entry into force of this Unified Patent Court Agreement, which requires this ratification process as explained before. However, the unitary effect can only be requested or will only be available for those countries who already have ratified. That means for some years we might have a rather complex situation. We have this agreement of between 25 different European states which agreed on this unitary patent system, but maybe in the beginning only 13 countries have ratified. Then the system will start first with 13 countries. Later, additional countries will join who then ratify later. So we have a rather complex situation where this unitary patent might cover different countries depending on the granting date of the European patent. Now, to understand the advantages of the unitary patent system for the patent prosecution, you have to look at the costs which you have for a classical European patent and compare it with the costs for the unitary patent. The cost aspect is, of course, one of the most important. First, if you validate a classical European patent in all these European states for which the unitary patent might be available, then you have different requirements for the validation in these countries. Some require a translation of the specifications and of the claims. Some require a translation only of the claims. Others, like Germany, France, and the UK, require no translation. So if you look at the result, you need for all these 25 European member states which participate in the system 9 different translations into 9 different languages of the specification and even 16 different translations of the claims into different languages. So you can imagine that this involves very high costs and is a big disadvantage for this system. However, if you validate only in a few countries, let's take the example, have a look at the example where you ratify the European patent only in the UK, Germany, and France. There, you do not need any translation for the validation. So still, if you want to have the patent protection only in a few European countries, the classical European patent can be more efficient cost-wise. What are the translation requirements for the unitary patent? So if the specification is available in English, the unitary patent will require no translation, as there will be provided machine translations. This machine translation will be set up in a project by EPO and Google. But this is true only after a transitional period, which lasts at least 7 years and can be prolonged up to 12 years. And during this transitional period, one translation has to provide it into any other official language of the European Union. So these translations are then used by the EPO and Google to set up this computer translation system in a proper way. This translation has no legal effects and is for information purposes only, therefore. Now, will it be cheaper, the unitary patent, compared to the classical European patent? Well, that depends. Depends on the number of states for which you seek patent protection. So obtaining patent protection for all the 28 European Union member states by means of a European patent today was estimated to cost about 36,000 euro. And compared to that, a unitary patent would cost, during this transitional period where you have to file the translation, about 6.5 thousand euro, so much less. And after this transitional period, when no translation would be provided, it's even cheaper. So if you want to have patent protection in many European countries of the European Union, then this unitary patent is what you are looking for. Now, another cost aspect are the annuities, the maintenance fees which are to be paid. At the moment, they are decided based on the so-called true top 4 proposal, which is the second column here on the left side. What does that mean, true top 4? This true top 4 maintenance fees are basically calculated from summing up the maintenance fees which are at present would have to be paid in the 4 topmost filer countries, which is Germany, France, UK, and I think the Netherlands at the moment. Of course, if the system continues without the UK, one has to, or others have to think about whether these high maintenance fees are still the proper ones, or whether they have to reduce them, because then without the UK you would have patent protection in less countries for the unitary patent. Now this is just a graphical representation. You can see the blue curve, that would be the costs for the maintenance fees compared to the maintenance fees which are at present have to be paid to the European Patent Office. Before you have the validation of the European patent, you pay the maintenance fees to the European Patent Office in a centralized way. Only after validation you pay it on a national basis. And the green curve, for example, would show the case where you have a validated European patent in Germany, France, and Great Britain only. So where you pay the maintenance fees only to these 3 national patent offices. Now, is it one patent to rule them all, this unitary patent? We saw that we have still a fragmentation of the European patent landscape because Spain does not participate, Poland did not sign the agreement, and for the UK, the situation is uncertain. And we, of course, have the situation that that only the European member states can participate in the system, but not the European countries which are not members to the European Union. We have a situation where we still have a coexistence of national patents, classical validated European patents, and unitary patents throughout Europe. And in a period of several years, we might have unitary patents which are valid or which cover different number of European countries because of this ratification process being necessary. So although the unitary patent does not provide a solution to all the problems, it would be a step in the right direction. A single patent, a unitary patent effective for 25 of 28 European Union member states, obtained through a single patent application procedure, relying on the established examination and grant procedure of the EPC, and effective upon registration and filing of a single translation during the transitional period, and afterwards no translation at all. And, as Detlef will explain later, enforceable in one single court with effect for all these 25 member states. Now, which patent to choose? That very much depends basically in which countries and in how many countries you want to have the patent protection. Actually, without going into any detail, you have to decide this on a case-to-case basis. Maybe I mention here that you have also for the unitary patent later a kind of forum shopping. Maybe Detlef can go into that later. So the costs provide a very important aspect for you to decide. Very important, I think, is also for you as the applicant, the administrative burden to manage these different national patent rights. Not only the sum of the total costs you pay as a legal fee and official fee, but also the costs which are involved in managing all these different national parts. On the other side, if you have the unitary patent right, this is vulnerable to a central attack during the lifetime of the patent. So it can also be revoked at any time by a single revocation suit before the Unified Patent Court with effect to all these 25 member states. Whereas having the classically validated European patent is much more difficult to revoke in many European member states, because you have to revoke it on a national basis at the national responsible courts individually. Yeah, the enforcement value due to this unified enforcement plays a role, and the predictability and quality of the decisions will be important. The quality of the decisions, we cannot say too much about that yet. The decisions of the Unified Patent Court are meant here because it does not exist yet. However, it makes use of judges which already have experience in the field of IP, and it's taken care for that these judges have a high experience. So as I said, in the end it will be a case-by-case decision. No easy rules. Now, here are potential benefits of the unitary patent for the validation phase. You have a reduction of the validation and publication fees to be paid with the National Patent Office, reduction in legal fees for the validation activity, and reduction in administrative burden associated with the validation. In the renewal fees, the reduction in the budget for payment of renewal fees if you seek patent protection in many European patent countries, member states. And you have an overall reduction in legal fees for the renewal activity because one single representative can carry out that task, whereas if you have a representative in each member state, then more legal fees will probably be due. And finally, as I said, again, the reduction in administrative burden with the renewals carried out by the applicant staff, by your staff. Yeah, other potential benefits of the unitary patent are listed here. They relate to business decisions. I don't want to go into detail here right now. Potential disadvantages of the unitary patent. We have, that I think is a very important point to say and to point out. We have a lack of flexibility with regard to the renewal fees. If you decide for the unitary patent, then this patent can be maintained as a whole or given up as a whole. But you cannot just give up some parts to reduce the costs, as you can do, of course, for a classical European patent. For a classical European patent, you can, if you have first validated in 10 countries and pay maintenance fees to 10 countries, you can later decide, okay, now the maintenance fees are too high for me, so I just give up maybe 2 out of these 10 countries where I validated the classical European patent, to reduce the costs. Such reduction, stepwise, as is possible for a classical European patent, is not possible for the unitary patent. And of course, you can validate only in a few number of countries with the classical European patent. For the unitary patent, either you have it as a whole or you have it not. So if you want to have patent protection in only a few countries, the unitary patent is not the right thing for you. We have the increased risk, all eggs in one bottom. A third party can revoke your unitary patent within one single procedure as a whole, with effect to all the participating member states. And a disadvantage of the whole system is that you still have not available the unitary patent for all European states, but only for the European Union member states, and even not for all European Union member states. So, such as Spain, Poland at the moment, and of course the UK, which is uncertain. Now we have uncertainty how the litigation system will work, and of course you as the applicant want to have certainty. This is most important for you. Now finally, after talking about patents, I just want to mention another possibility to protect your technical inventions, which is the utility model, which is available in several European countries, but not in all. And I'm a German patent attorney, so I would like to talk about the German utility model. Also, for you, if you decide whether you want to have a protection in one or more countries, depending on the industry which your company belongs, it might be worthwhile to think to have the protection only in one country, namely in the country which provides the most important market. That might be Germany. Or other industries like the pharmaceutical industry, of course, they need a patent protection in most of the countries. For them, it's no good choice to have the protection in only one country. So that depends on the industry. The German utility model, we have no substantive examination. Means no examination of novelty and inventive step, but just a registration process. Just some formalities are checked and then your utility model is registered. So the registration is rather predictable and involves low costs compared to the costs for attaining a patent, for which you have to spend the money for the examination procedure. Now, the registration of the utility model is very quick, within 4 to 6 weeks after filing, and that allows you to enforce this IP right, the utility model, very quickly, much more quickly than a patent for which you have to wait for grant. Now, what are the basics of the utility model? Utility models can protect devices, but no methods. They are not available for method claims. You have an optional search for a relatively low official fee, which is really very low. I don't know how the German Patent Office can do that for such low office fee. So you can get an idea for a very low fee about the validity of your utility model. The maximum duration, however, is shorter than for a patent. It is 10 years, not 20 years. The big advantage is the grace period, which is available for a utility model, but which is not available for a German patent or for the European patent, for example. So if the applicant already has made a publication of its own invention, he can still file a utility model within 6 months, which would not be possible for the patent, which would then be invalid due to lack of novelty. And also, despite the fact that the standards for deciding whether you have inventive step are pretty much the same or are exactly the same, the prior art considered for the novelty and inventive step is different. Less items belong to the prior art for a utility model compared to a patent. So, for example, oral disclosure would be no prior art for a utility model. If you have told some third party, this is no prior art for the utility model. And also, prior use outside of Germany, if you have already sold a system which is an implementation of your invention, then this is no prior art for utility model in Germany. Only prior use in Germany would be prior art. So you may think about the utility model as a very cost-efficient way to protect your technical inventions in Europe. So that's about what I have to say. Thank you for your attention, and if you have questions, you're welcome to raise them later at the tea break. Thank you.